Hello, my name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2020 Harlan Institute Ashbrook Virtual Supreme Court competition. Today, we're arguing the case of Torres versus Madrid, and this is the Elite Eight round. We have two excellent teams today. For the petitioners, we have Makaylia and Elizabeth from Creekview, Texas. And from Dallas, from the Judge Barefoot Sanders School, we have Avery Rose and Brooke Sanchez. I'm happy to welcome three esteemed judges, Christopher Riano, Rachel Van Landingham, and Jeff Korn, who'll be presiding today. Without further ado, Chief Justice, may begin.
Good morning. My name is Christopher Riano. I am the president of the Center for Civic Education and a lecturer of constitutional law and government at Columbia University. I'm very excited to be here today, along with my fellow judges. And please take a second to introduce yourselves, and we can get into arguments. If the petitioners want to introduce themselves.
Good evening. Sorry, excuse me. Good evening. May it please the court. My name is Makaylia Askew, and along with my co-counsel, Elizabeth Adeoye, we represent the petitioner, Roxanne Torres.
Today, we are arguing that Torres was seized under the Fourth Amendment because 1, at common law, a seizure does encompass an unsuccessful attempt at detaining a suspect, and 2, when comparing false imprisonment to an unsuccessful arrest, there's a clear violation of the Fourth Amendment. And lastly, 3, the lower court's ruling is inconsistent with the ruling found in California v. Hodari D.
In 2014 in Albuquerque, New Mexico, 2 police officers, in an attempt to stop a woman named Roxanne Torres fleeing, shot her, hitting her twice. Despite this, she was not physically detained until she was admitted into the hospital. In 2016, Torres filed a civil rights complaint in federal court against the officers, claiming that the intentional discharge of a force is exceeding the degree of force which a reasonable law enforcement officer would have applied. The court held that the officers were entitled to a qualified immunity and was reasoned that the officers had not seized Torres, and therefore there was no Fourth Amendment violation.
The Fourth Amendment refers to seizures of persons. That language was used interchangeably with the term arrest when the Fourth Amendment was drafted and ratified. At that time, the meaning of arrest under the common law was clear. Under the common law rule, the application of physical force for the purpose of detaining a suspect constituted an arrest, regardless.
Counselor, may I interrupt and ask a question?
Of course, Your Honor.
So what level of deference should we give to the 10th Circuit's decision here that contradicts your position? I mean, the 10th Circuit said that your client was not seized.
Well, Your Honor, today in this court, we are trying to find whether or not we have precedent that shows that a seizure did occur. While we have other precedents that the respondents may mention, we can look towards the common law rule, which is one of the most original reasonings we have behind the definition of seizures and such. And that's why we should look at this more than what the 10th Circuit said previously.
What is your authority for that common law rule? Where do you derive that from? Your definition of arrest in the common law?
Well, we look towards California v. Hodari D.
It wasn't in California v. Hodari D when they were speaking of the contours of a seizure. Wasn't that just in dicta of when physical force is used?
Well, yes, Your Honor, it may have been in dicta, but today we are just looking towards not the precedent that is set directly towards with the holding of that case, but we're looking towards the definition that were set. And we can also see that this is clearly not dicta.
Well, did the 10th Circuit completely ignore Hodari?
Not necessarily, Your Honor. They did not completely ignore Hodari D in this case, but we can see that they did use some parts of the ruling they used some parts of Hodari D to find their ruling. However, they did not fully use Hodari D, and that is why the ruling is inconsistent with the ruling.
Counsel, how does somebody use half of a ruling and not another half of a ruling?
Well, not necessarily the ruling itself, but also the precedent that they set in that case, such as the definitions of seizures.
Well,
but their precedential effect. Let's get into that, Counselor. What is a precedential effect of a Supreme Court case? I mean, there is, you would agree, correct, that there is something that is precedential, and then there's the dicta, right? And we have to very carefully parse what falls into what.
Yes, Your Honor, I do agree with that statement that we need to look at the precedential effect. And the fact of the matter is that what we are looking to directly for the precedent in this case, what we are arguing is not dicta, and that is why we are in this court today. However, what the 10th Circuit Court may have done with the dicta and the precedential effect may have been different.
Can you help?
Go ahead.
Can you help us out and put your finger directly on the bullseye of where you believe the 10th Circuit got Hodari wrong?
Okay, well, Your Honor, as I will address, just as I was about to address in my argument, as found in California Hodari D, these words should have naturally been understood by those who ratified the amendment as incorporating the concept of an arrest. The part where the 10th Circuit Court got wrong is that they did look towards California v. Hodari D when defining a seizure, and the 10th Circuit Court found that this shooting in this case did not constitute a seizure, which is where we find that they made an error.
Well, counsel, let me ask this, and let me ask this of your co-counsel too. I mean, do you really think that you can parse precedent and not parse precedent in this fashion?
Yes.
Please go ahead.
Yes, Your Honor. Several courts before us, such as Florida v. Jargons and in 1964 course Hoggs v. Marks, has used precedent only half of a ruling, like using a dissent from Florida v. Jargons or a majority from Hoggs v. Marks to determine their ruling. In today's case, the petitioner's contention is to use the ruling of California v. Hodari, the common law definition of arrest, to determine that today's case, Torres was seized and thus unconstitutional under the Fourth Amendment.
Counselor, let's follow up on that, because, and this, we're not talking about an arrest, right? For your client, she's contesting the seizure component of being hit by bullets, but she was not arrested at that. You're not trying to tell us that she was arrested at that moment, are you?
Well, Your Honor, actually, under the common law, arrest and seizure can be used interchangeably. But not by the Supreme Court. They can be two different things. I mean, an arrest is the quintessential seizure, but a seizure is much broader. So, are you arguing that your client was arrested? Yes, Your Honor. Under Hodge v. Marks, they state that during the founding era, which is what we want this court to look at when determining the ruling of this case, an arrest occurred, which is also a seizure, when the officer touched a person with the intent to arrest them, even if they did not immediately succeed in detaining them. In today's
didn't Hodari hold that if an officer physically seizes an individual, they are in fact seized for purposes of the Fourth Amendment, but if they break away and then run, there's no such thing as a continuing constructive seizure?
No, Your Honor, I believe that Hodari also held that even if the attempt at detainment is unsuccessful, the suspect is still seized under the Fourth Amendment.
While the suspect is running?
Yes, Your Honor. In today's case, Officer William in Madrid acknowledged that they shot Torres in an attempt to stop her flight, and Torres' subsequent flight is therefore analogous to an escape at common law. And although only for a short period of time did she escape detainment, she was nonetheless arrested the moment they applied physical force.
Counsel, that's not what your brief says. I mean, your brief says that you're not arguing that she was arrested that entire period. You're arguing that there was a seizure that occurred that's analogous to it's analogous to common law arrest, because an arrest was a seizure, but the analogy isn't that it was an arrest per se. The analogy is that it was some application of physical force. So can we switch to intentionality unless someone else wants to, because I'd like for you to address that.
Sorry, could you repeat the beginning of your question? You cut out.
Sure, your brief stated that your brief didn't argue that there was an arrest. You're now telling us that you're arguing that there was a continuing arrest the entire time. But your brief argued that there was a seizure that occurred when she was shot. You didn't argue that that was an arrest. It was analogous to the arrest in the fact that it was an application of physical force, even though it was unsuccessful in the ultimate detention, because she wasn't detained, as your co-counsel told us, until later on at the hospital.
Excuse me, Your Honor. So when looking back towards California v. Hodari, when determining whether or not a seizure is unconstitutional, they made it clear that this intricate analysis is not necessary when an officer applies physical force in an attempt to apprehend a suspect. In today's scenario, the common law mode of analysis has the additional benefit of simplifying straightforward cases as found in Florida v. Jargons, and it is undisputed that an officer conducts a search or seizure when she physically intrudes on a private citizen's property to gather evidence. In
But
today's
all of that may be undisputed, but aren't you just jumping over the taken under control aspect of Hodari? I mean, wasn't that a big part even of their analysis of the common law notion of arrest? There was citation to prize cases that indicate that a ship under attack is not seized until it's actually captured. So isn't there an analogy here? You have a physical application of force, but the individual is not yet taken under control.
Well, not necessarily, Your Honor. The issue before today's case is that the physical application of force, regardless of the successfulness of the detainment, is a seizure. The police officers invaded Ms. Torres's property, which is her own body, and therefore it equates to a seizure.
Does your co-counsel agree?
Are you asking me, Your Honor, or my
Yes.
co-counsel? Well, I would agree with what she said, yes.
And so you find that to be a seizure?
Well, yes, Your Honor, if we're looking back to the common law definition and what is found in California v. Hodari.
Can you elucidate a little bit further on what one of my co-judges asked about when it comes to the common law foundation for that argument?
Well, Your Honor, if we're looking towards the common law definition that is given in California Hodari D sets that the Fourth Amendment seizure requires some sort of physical force with a lawful authority or a submission to assertion of authority to constitute a seizure.
But no taking under control.
No, Your Honor.
But isn't Hodari really not helpful in this case, and probably why the 10th Circuit was able to circumnavigate around it? Because Hodari was a submission case. It was a show of authority case until he was tackled and immediately arrested, right? That physical force culminated immediately into an arrest, into full detention. Initially, though, right, there was no submission to a show of authority, and therefore the court stressed that show of authority, and that allows respondents to say, look, there's got to be submissions. There has to be that submission and able to bring in Mendenhall. So, I mean, I have a hard time with you saying that that Hodari's precedential here. If it was precedential here, why would we have granted cert in this case? We would have said asked and answered.
Well, Your Honor, if we're looking at the facts of that case, we can see that yes, there was not a submission to an assertion of authority, but we can see that in Hodari, it is said that a seizure requires some sort of physical force, which is what we are looking at when we are arguing in today's case.
And that's what respondents say is clearly dicta, and I think I'd have to agree. But dicta can be helpful. It's okay to have dicta. It's very helpful dicta for you. So what about Mendenhall? How do you address respondents' claim that Mendenhall, clearly on a Mendenhall test, your client was not seized until she was arrested at the hospital?
Your Honor, could you repeat that question? You cut out for about maybe 10 seconds in the middle of it.
Sure. How do you address the respondent's use of Mendenhall?
Well, Your Honor, as in the when comparing today's case to false imprisonment, as in the false imprisonment context, the species of seizure includes an additional objective element in regarding a subject's submission to the officer's show of authority, and particularly when a reasonable person would have believed that he was not free to leave. And as stated in United States v. Mendenhall, this objective is inquiry looks to factors nearly identical to those examined in false imprisonment cases, which also including the threatening presence of several officers, the display of a weapon, some physical touching of the person to the citizen, and the use or tone of the voice. In today's case, Ms. Torres was in her car, unaware of the fact that the people behind her, next to her car, were police officers. Their first instinct when Ms. Torres believed that she was being carjacked and moved her car an inch was to shoot at her 12 times, not at her vehicle that actually posed the created perceptive of a threat. Now, does that answer your question, Your Honor?
It does, thank you.
The analogous Fourth Amendment common law imprisonment tort actually utilizes a similar analytical structure to the one used in California v. Hodari D. Like a common law arrest, the common law false imprisonment distinguishes restraint by fear and restraint by force. Specifically, a plaintiff asserting a common law claim of false imprisonment must demonstrate that the resistance of their personal liberty of freedom of movement resulted either from force or from fear. This tort protects the sacred right of every individual to the possession of and control of his own person.
Which means that the tort is at the center of the tort is the fact that somebody else has asserted control over the victim.
Yes, Your Honor.
Again, I want to make sure I understand this very clearly. Your position is that any application of physical force qualifies as a seizure because it would qualify as a common law arrest, even if that application of force does not result in the police officer securing control over the individual.
Well, we must also look at the intent of the police officer. If the police officer was
Given the officer is intending to assert control over the individual, but fails to do so, you believe that qualifies as a seizure?
In this case, it does, Your Honor.
Because there was an application of physical force that was ineffective in achieving the intended goal.
And because eventually Miss Torres in this case did have to stop at the hospital and was eventually taken into detainment by the police officer.
So why couldn't we say she was seized at that point?
At the point that she arrived at the hospital or the point that she was shot, Your Honor?
Arrived at the hospital and was actually lost her control over herself.
Well, we find that at both points she was seized.
Okay.
So how does the intentionality work? Because the case in which we decided the roadblock case, didn't we stress intentionality?
Yes, Your Honor, we did, but we can look clearly that there is intentionality in this case because of the reason why the officer shot at Torres.
Sorry, I was going to add on to my opposing counsel's answer. I believe you're mentioning Broward v. City, Ino County. In that case, the court found that because of the roadblock, that was an illegal seizure under the Fourth Amendment. And it's the petitioner's contention that as a roadblock of the police officers is an illegal search, so should shooting a suspect 12 times also be an illegal search.
Thank you, counsel. I appreciate that. And we are now 40 seconds over. So I appreciate the answer. No worries. I want to turn to the respondents to give them a chance, obviously, to have their part of the case. Counselors, you may begin.
Good morning, Your Honor. My name is Brooke Sanchez, and alongside my co-counsel,
Avery Rose.
and we represent the respondents. Now, the issue presented before this court is whether an unsuccessful attempt to detain a suspect by the use of physical force is a seizure within the meaning of the Fourth Amendment, or must that physical force be successful in detaining a suspect to constitute a seizure? The answer to that question, Your Honors, is yes. The unsuccessful attempts to detain petitioner by using physical force is not a seizure within the meaning of the Fourth Amendment for 4 reasons. First, we contend that this court should see to the public meaning of a seizure throughout American history. This seizure requires restraint of one's freedom of movement, as adopted in Broward v. County of Inyo and Brenlin v. California. Though officers Madrid and Williamson succeeded in hitting petitioner, they failed to restrict her movement in any way. Not for a moment.
Ms. Sanchez, can I interrupt you? The facts indicate, and your opponents argue, that that's just patently wrong. That once a bullet is lodged in the victim's body, their freedom of movement has in fact been substantially curtailed because it necessitates immediate medical care, which required the individual to go to the hospital. Are you arguing, just so I'm clear, that if a police officer shoots and hits a fleeing suspect, that is identical to a police officer yelling stop and the suspect keeps running? The fact that there's a bullet lodged in the body makes no material difference.
Yes, Your Honor. The fact that a bullet is in her body does not make a difference because it is the definition of a seizure is possession. If this bullet has not possessed the body in anywhere where the police have now control over her next movements, Ms. Torres,
Council, where's case law that shows that in which this court has decided that seizure is possession? I don't recall reading that in Terry v. Ohio or Mendenhall or Hadari or Wardlow or the many, many cases that we have in the line of seizure.
well, Your Honor, we can see it in Broward v. County of Inyo, where if the police accost an individual and has restrained their movements to walk away, that is in fact talking about possession. They control the boundaries in which this person may move, may leave. Their next actions are dependent upon the person who has them in possession. The bullet does not control possession.
And not only that, but you can also see this in the hundreds of years worth of dictionary definitions. I mean, the founding fathers consciously used the word seizure in the Fourth Amendment. They knew what it meant and knew what it would mean to the everyman. You know, dictionary definitions have described seizures as taking possession from Noah Webster's original American Dictionary of the English Language, all the way to John Bouvier's Law Dictionary during our country's early days.
Did we
But
emphasize-
counsel, what
we
did the
emphasize-
what did the founding fathers feel were the core values behind the Fourth Amendment?
Well, Your Honor, the Fourth Amendment was originally created to eliminate general warrants and to
Core values. What are the core values? What does the Fourth Amendment protect we the people from?
It protects us from arbitrary search and seizure,
But what are the values
unreasonable.
behind, without using search or seizure, what are the values behind the Fourth Amendment? Don't use the term search and seizure, please.
It protects us from arbitrary encroachment by the government.
Encroachment on what?
On personal liberty and on
Personal liberty or personal privacy?
On our personal privacy, rather, and on.
And how are those different, counsel?
Personal liberties are what we are able to do in terms of our right to, free speech and our rights to bear arms.
Is the autonomy over my own physical body to control who touches me and who doesn't touch me? Is that part of my personal liberty, counsel?
Yes, it is part of that, Your Honor. But when specifically describing the intent of the founding fathers, it was to eliminate the general warrants and to eliminate the ability for government to arbitrarily and randomly encroach on people's privacy. And
I'd like to go back
right
to Ms. Sanchez and ask a more direct question.
Thank you.
Both of you are focused on this possession element. Did we emphasize that in Hodari? Hodari seems to be the key precedent here. Where in Hodari, if at all, did we indicate that a lack of possession negates a claim of seizure?
Well, Your Honor, in Hodari D, it specifically says that from the founding of the Fourth Amendment, it has the definition of a seizure has encompassed the word possession. And now Petitioner has repeatedly failed to prove
did we illustrate that in any way in Hodari?
No, Your Honor, and that is exactly why Hodari D is dicta and is not binding on this case, because there
was no discussion of whether the fact that Hodari was running from the police officer when Officer Petroso was yelling at him negated the claim of seizure?
Yes, Your Honor. It was not a seizure because the police could not control where the suspect could go, where the suspect could flee to. There was no sort of boundaries in which he was controlled under the police officer.
I'm going to ask you a quick hypothetical. I want you to imagine, as we've all seen on the news, that police officers employ a taser against a very large, strong, belligerent suspect, and the taser does not effectively disable the suspect. The prongs are in the suspect. The cord is still connected to the officer, but the suspect is still resisting and trying to flee. Has he been seized?
No, Your Honor. He has not been seized purely for the fact that the police officer has not been able to take control of the large man. Be it as it were, he was tased, but he was not able to be his boundaries were not created by the police in which he would not be able to do anything other than submit to the police.
Even though.
So what if he was running and the police just yelled at him, no taser, yelled, "Hey, you stop." And he turned around, stopped, looked at the police officers, then continue his flight. At the moment he turned around and stopped, even though police had no physical control over him, is that a seizure under Hadari, under the strict reading of Hadari?
Well, under Hodari, Your Honor, they would consider that to be a seizure, but that is a show of authority, a seizure. But petitioner fails.
Also, there is
to draw
a
the
distinction
line.
between the Hodari case, which is all about show of authority, and physical force.
Yes, Your Honor. And Hodari D, under petitioner's analogy between this case and our case, they fail to draw the line of where does the seizure begin? Where does the seizure end? I really agree with Justice Jeffrey about Hodari does state that a seizure is a single act. It's not a continuous act. Petitioner was seized the moment that she was at the hospital, and the police had then restrained her freedom of movement. She was then in their custody.
But Miss Sanchez, for either one of you, isn't there a fundamental difference? In Hodari, they referred to a situation where the officer laid physical control on the suspect, and then the suspect broke away. So the suspect was completely separated from that exercise of physical force. Here, we have a suspect who has not been separated from the exercise of physical force because the projectile is still inside the suspect's body, impacting the suspect's liberty and autonomy over their physical person, which, according to Mr. Rose, in response to Justice Van Landingham, was one of the fundamental objectives of the Fourth Amendment.
Well, Your Honor, the fact of the matter is that it didn't really restrict her movements. She ended up leaving the scene of the crime and traveling 75 miles well beyond that.
Mr. Rose, I've never been shot, but I suspect that if I was shot with a bullet, my autonomy and freedom would be substantially impaired. I couldn't just go watch a football game and sip a soda and say, at some point I'll go to a clinic and see if they'll take this bullet out of my back.
Well, Your Honor, that brings us to another part of our argument that petitioner was free to bring a 1983 lawsuit alleging a violation of the 14th Amendment. There was no seizure, but petitioner was not limited to bringing forth the 14th Amendment. This court in
why does that foreclose the petitioner's opportunity to actually allege a Fourth Amendment violation?
Well,
I mean, couldn't you have a violation that crosses lines between due process and the Fourth Amendment?
Well, yes, Your Honor. If there was no seizure, then no Fourth Amendment could take place. No seizure. There could be no unreasonable seizure without a seizure. That is why the 14th Amendment is a second option in which Ms. Torres could have filed. This court in Sacramento v. Lewis establishes the standard used to prove a substantive due process claim. The action must shock the conscience of the court.
Counsel, don't we have to worry about looking forward into other cases? We need to have a good line in which police officers know when they're seizing someone and when they're not. Because what if you don't have a shock the conscience case? What if I'm walking down the street and a police officer grabs my arm with the intention to stop me and I keep walking? So grabbing an arm, I don't think is going to shock the conscience. So when he grabs my arm, even though I keep walking, under your argument, I have not been seized. And so and what if the police officer just grabs arms of short women with long hair because he doesn't like us? That's arbitrary. And so that arbitrary action by the government into my autonomy, my personal liberty, there's no constraint on it, even under the 14th.
Your Honor, there would be constraints on that. If the police officer grabbed the arm of the person and they stopped their movement, even momentarily.
But I said they didn't stop my movement. Okay, let's say they don't stop my movement. They just they reach for me and they maul the front of me, right? But they don't stop me because I've kept on walking. There's no, I'd never physically stop. But yet they've non-consensually touched me. Isn't that analogous to non-consensual touching? And this court announced in the Jones case, non-consensual touching, a physical trespass onto the person's Jeep with intent to search. That was a seizure of a car. If that's a seizure of a car, why wouldn't that same thing be a seizure of a person? So my Jeep has more rights than I do as a person.
Well, Your Honor, I think you're getting more into the unreasonable section of a seizure, which we're not arguing before this court, because you're asking this court to assume that a seizure even took place in the first place. And
That's not, counsel, that's not how I understand the question from Justice Van Landingham. The question is, how can putting a device on a car, a trespass on a chattel property, qualify as a search, even though the car is driving all around DC, but putting a bullet into somebody's body not qualify as a seizure? That's the specific question you need to ask to help us reconcile Jones with this case.
yes, Your Honor. Now, those are search cases, and this is a seizure case.
Okay.
For the search case, there was an intent to search the vehicle, search a cell phone record, search a house, as in Kylo discussed, but those intentions were satisfied. They were able to get the information that they needed. In this case, a seizure must be successful with the intent to stop the person. The bullet.
So how do we know, Ms. Sanchez or Mr. Rose, when a physical trespass on a person or their effects should be analyzed as a seizure instead of a search?
We know when it has been excuse me, wait, can you repeat your question?
I'll repeat.
Sorry about that.
No, it's okay. When do we know, because this is going to drive our application of controlling jurisprudence, when do we know when the physical trespass on a person or their effect should be analyzed as a seizure under Hodari versus a search under Jones?
So when it comes to a seizure under Hodari, we'd know if the intention was to limit their movement, if it was a show of authority with the intent to limit their movement, rather than with a search, which would be to investigate their belongings or investigate their person.
Okay, so you think motive is an important factor in distinguishing between those two?
Yes, Your Honor, intent specifically.
But Counselor, that is interesting, because what if the police officer in front of your client did not intend to shoot her car, which we obviously know they did with the 12 to 13 bullets. What if instead there was an accidental discharge of their gun and it hit her and she still drove away? So we would no longer have a search at that point?
Or seizure?
Yes.
Or a seizure, excuse me, would no longer have a seizure?
Yes,
No,
Your
Your
Honor.
Well, a seizure has to encompass the intent rule. If the police were not intending to stop her or intending to stop her vehicle, there could not have been a seizure. And more importantly, you're saying that the car kept going. The person was able to evade the police's capture or possession. There could be no seizure. And I see that my time is running.
No, Ms. Sanchez, please continue, because we're going to be adding a little bit of time because we gave the petitioners a little bit more time.
Are there any more questions?
Mr. Rose, I mean, here's the question. I think we are looking at searches, we're looking at seizures. I think you can hear from my fellow justices that we're very interested in your opinions on this and the differentiation of this case line. So as we've added time, I would like to hear a more concrete answer on how we can differentiate this, because what we decide is obviously going to be precedential moving forward. Mr. Rose, please.
So we've got 5 extra minutes, just so we're all on the same sheet of music. 4.5.
Oh, got it. Okay, so to distinguish between a search and seizure comes down to the intent, as Justice Korn said. When it comes to a seizure, you are trying to limit the person's movement. You are trying to stop them. When it comes to a search, you are trying to investigate their belongings or their person. It is separate. They are two separate lines that involve two separate sets of cases.
Mr. Rose, I think we would all agree that in the law of common law battery, if I use a projectile to inflict physical touching on the victim, then that qualifies as a battery. It's an extension of my body. I would see a bullet as falling within that category, certainly for the case of a battery. So again, what I really need your help with is understanding why an officer who grabs a suspect and then the suspect breaks away, so there's no longer an extension of the officer's physical touching, doesn't qualify as a seizure. I think we all agree with that under Hodari, but how leaving a bullet that I fired with the intent of seizing the suspect in the body is remotely analogous to the suspect who's running away and can do whatever they want after they get out of my sight.
There are two separate parts to this. First is when it comes to common law in itself. The common law in this case should not control the ruling. We have several cases in our American jurisprudence. We have Brower, we have Terry, we have Brindlin, all three of which agree with our definition of seizure, and which we have used across.
And not one of which considered whether leaving a bullet in the victim's body qualifies as a seizure. So be a little bit cautious in your emphasis of the controlling authority.
Well, Your Honor, petitioner has failed throughout their entire oral argument to give you any case law regarding their common law definition that talks about projectiles. There is a case, the Countess of Rutland's case, the Mace case, where there is a more show of authority through the officer saying you are under arrest, and he touches the person with the extension of an object. There is no common law case that encompasses projectiles. There's no common law case that talks about leaving a bullet in anybody.
Well, what's the relevance of that? What's the relevance of that case? I'm curious. You just told us about this interesting touching the victim with a mace and saying you're under arrest. Was that an arrest or not?
It was a show of authority, and there was submission. The person did in fact stop and was under the possession of the officer. Now, the purpose of this was that petitioner has failed to bring forth a common law case. The Countess of Rutland's case is a common law case in which it just doesn't apply. Common law does not apply because in all of those cases, there was a submission to that authority. There was a submission to, if you would like to say that the mace was a physical force, there still was stoppage.
Counsel, do you think if your client had been shot, but the bullet went through her, so she's bleeding and still able to drive the 70 or so miles, but the bullet wasn't lodged in her, do you think it's dispositive that the bullets were still in her body? Or is it, for this case, should it be?
Your Honor, if the bullet went through her and she is still driving, that is still consistent with our definition of a seizure. She was not stopped. She was not confined within the boundaries of which the police were intending to stop her. The petitioner has failed to draw the line of where does the seizure begin and where does the seizure end.
And how does that, how is that hew to the founding fathers' driving purpose behind the Fourth Amendment, which in your co-counsel's terrific words was to protect against arbitrary intrusion into our personal liberties of privacy and security?
Well, yes, at the founding of the Fourth Amendment, they wanted to get rid of the general warrants and they wanted a more specific warrant.
But they didn't say that. The Fourth Amendment doesn't say, hey, the only thing we're worried about is general warrants. It says we're worried about unreasonable searches and seizures. Right.
Yes,
and so you're saying the police officers can go up and slap us, can shoot us, but as long as we don't stop, it's not an arbitrary intrusion into our liberty?
One sentence.
Or is that the point, Ms. Sanchez, where you would say you're barking up the wrong right in the Bill of Rights and you need to move to the 14th Amendment due process clause?
Yes, Your Honor. As I stated before, that is in fact when the 14th Amendment would come into play, because without a seizure, there cannot be a violation of the Fourth Amendment. And I see that my time is running out, and if I may give the conclusion of our argument.
Very quickly, counsel.
Now, ultimately, an attempt to detain a suspect by the use of physical force, it must be successful to constitute a seizure within the meaning of the Fourth Amendment. This is the line with both the original and contemporary public definition of the word, and as well as American jurisprudence such as Terry, Brower, and Brindlin, because petitioner has failed to bring forth any reasonable common law case. Additionally, petitioner's theory relies heavily on Hodari D, which is purely dicta. Common law arrest cases are not helpful nor useful. Finally, this court does not need to twist the definition of a seizure to increase police accountability. The police can be held accountable under the 14th Amendment, which we have discussed as the due process clause, and under state law in certain instances. And with that, we pray that we find in favor and affirm the lower court's decision. Thank you, Your Honors.
Thank you, counsel. And the petitioners obviously will have a chance to rebut. And I do want to turn to them at this point and give them their due time.
And may it please the court, I'll be addressing or summarizing my rebuttal into one point before the court today. And it's simply that Torres was seized in today's case. The opposing counsel states that the court should view the definition of seizure under Broward v. County, Ohio, which states that the court's decision should be completely dependent on the possession of the officer. However, as stated before, the opposing counsel also uses the founding fathers' definition of the Fourth Amendment. And even before this approach was even embraced, several courts were already describing the significance of this rule as shedding light on what the framers of the amendment might have thought to be reasonable. And as found in Peyton v. New York, which is a common law specific case, it states that the Fourth Amendment is to be constructed in the light of what was deemed unreasonable search and seizure when it was adopted, and in the manner which will conserve public interest as well as the interest and rights of individual citizens. And therefore, in today's case, even though Torres momentarily eluded detainment, she was still seized under the common law definition of the Fourth Amendment. Opposing counsel also contends that because Hodari is a show of authority case, it is completely dicta. However, relying on a narrow construction of the issue in Hodari making their case, but even under that level of specificity, Hodari is a Fourth Amendment case and therefore instructive to this court. And even this court were to look away from Hodari, Terry v. Ohio explained that the Fourth Amendment seizure occurs when an officer restrains the liberty of a citizen in which of one of the two wants, either by a physical force or by show of authority, and that a seizure of physical force occurs by the laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful. The opposing counsel then also states that an officer grabbing an arm of a suspect is a seizure. However, under this analysis, the facts of today's case should as well be seizure because the officers in today's case went even further than grabbing a suspect and actually shot at Torres, which is a seizure. And lastly, Your Honors, like the exclusionary rule and the fruit of the poisonous tree doctrine, allowing petitioners like Torres to recover through the due process claims gives teeth to the rights guaranteed under our Constitution. Under the respondent's rule, police misconduct is acceptable as long as it is ineffective. This interpretation would exclude the constitutional review erroneous scenarios from an individual posing no threat, continued movement after an officer struck them with a bullet.
But wait a minute, counsel. Your opponent specifically acknowledged that what happened here may give rise to a substantive due process violation. Their argument that this is not a seizure is not an endorsement of police abuse of citizens. That's certainly not how I understood it. So what we have to do is decide which is the right and most appropriate constitutional protection to govern this type of activity. How do you support the claim that denying this as a seizure is an implicit endorsement and license for police abuse of citizens?
Well, Your Honor, I believe we should look at the intent of the police officers and the amount of force they use. In today's case, the officers intended to shoot Torres and shot her 12 times, which ended her up in the hospital, which under Terry v. Ohio and California v. Hodari, because of this application of excessive force, it is a Fourth Amendment seizure case.
I understand that. I understand that's what you're asking us to decide, but I was caught a little bit off guard by your comment a few moments ago where you suggested that ruling against your position is somehow a license or incentive for police abuse. But your opponent specifically acknowledged that there's an alternate remedy within the Constitution in 1983, which is to allege a due process violation.
Well, Your Honor, I do have to disagree with the opposing counsel's contention that it is due process because the officers used physical force in today's case, which is under the Fourth Amendment protections under search and seizure. Police officers should not be allowed to first shoot at a person who is perceiving as a threat when it is their car, their vehicle that is the threat, not the person itself.
So if a car were running into you to run you over and you were armed with a firearm for self-protection, you don't think it would be reasonable to shoot at the car?
Well, no, Your Honor, I believe it'd be actually more reasonable, or excuse me, it would be reasonable to shoot at the car. However, the officers in today's case specifically shot at Torres herself instead of the actual vehicle or the tires of the car. And I see that my time is eluded. May I pray before the court?
Please.
It is for these reasons we pray that the court rule in favor of the petitioner, Roxanne Torres, and reverse the lower court ruling. Thank you.
Josh, are you coming back on to tell us the procedure? Are we allowed to compliment the phenomenal performance of high school students that make me think they're lost?
No,
Yeah.
Yes.
incredible.
Please, everyone, this
Killers,
was,
man. You
this was
guys
remarkable.
You guys are killer.
Please, other team back in the
Better
camera.
go.
Everyone back in camera, please.
You better go to law school.
I know.
If you don't go to law school, it's going to be a due process violation.
Yeah, I felt like
It-
this was law school. I couldn't
Oh my
agree more.
God.
It shocks the conscience if you don't go to law school. It's not a thing.
Seriously, you guys were just smoking.
Well, and I loved so many components of both petitioners and respondents' arguments. You let us push us and you push back, and that's exactly what you need to do. I love that you wouldn't cede ground, never cede ground, well, unless it's reasonable to do so. But I love the fact that you took the hypos, with the respondents took hypos and stood their ground and said, nope, that still wouldn't be a seizure, even
And
if
you
the
had-
police
and
officer
you-
mauls you.
And you had what Professor Blackman will tell you is called a hot bench, right? You didn't have a bunch of passive judges. You don't know what you get when you get these former Army JAGs. Our whole existence was to question authority. So that's what, boy, you guys are just remarkable.
Let me-
I wish your parents were here so I could tell them how proud they should be of you, because just superb.
Let me jump in. I've been doing this tournament now for almost 8 years. I think this was the hottest round I've ever seen, without question. I knew when invited Jeff and Rachel would be hot, but man, this was hot. They were throwing bombs at you and you just took them and you didn't move an inch. One of the hardest things to do in an oral argument is to stick to your gun, to stick to your position. And when you have these very sharp judges saying, well, what about this? And what about this? And what about this? What they're trying to do is knock you off your position. Because once you deviate, say, but counsel, you wrote in your brief X, and now you're saying why, how, and then you're done, right? Once you move that, you're toast, right? Because you don't have a position anymore. You have nothing to stand on. And the four of you, my goodness, did not move an inch. They're asking, what authority? Well, that's not the right authority. And what about this authority? And I got to tell you, I've known Jeff for a long time, I've known Rachel a little bit less. They treated you the same way they would have treated a third-year law student in a moot court tournament. And you guys could walk into law school tomorrow and just kick butt. You could just walk into law school tomorrow and thrive.
Do it. Skip college. Just come.
These students are and they're very good coaches. The parents, coaches should all be proud. But this was something that you could walk into law school tomorrow and you could win a moot court tournament. I have no doubt in my mind. It's
100%. I forgot that you were high schoolers. I'll be honest. Now I want to apologize, but I don't, because you met the challenge.
What are you guys, 16, 17 years old?
It's unbelievable.
How old are you guys?
16.
16.
18.
How much?
18.
Oh, you and I both, Makaylia. Yeah, right.
Okay, so 16, 17, 18 years old. My goodness. Well,
I've seen 30-year-olds I've seen practicing attorneys can't handle questions like that.
You should be
Chris?
proud of yourselves. I'm sure you put a lot of work in it. I think Thomas Jefferson said, I'm a great believer in luck. I find the harder I work, the more of it I have.
Chris, you want to get some comments?
I was just gonna say, take a deep breath, because I know how intense that was. There's nothing like having a panel of prosecutors. And as a former criminal and civil prosecutor myself, I'm the first that can tell you that is about as good of a panel as you're gonna get. You all did phenomenal. That truly was better than most of my students at Columbia.
Well, the problem is that Jeff and I both teach. I'm about to give my students their criminal procedure exam. And so Jeff and I are so in these issues that, but I love the fact that we were even I mean, I loved all the arguments. I love that you were holding your ground. I mean, I love that we were really trying to plumb for petitioners, the common law, and trying to show, this is important. This is an area that needs to continue in the Fourth Amendment. That was beautiful. Respondents, I love that you stood your ground. I honestly thought, oh my God, especially after reading the Supreme Court case, right? You're like, what can respondents say? How can they even make this a strong argument? And you brought it.
So let's take a poll. Who thinks the court decided the case the right way?
I do.
Because I'm with Gorsuch, sorry.
Brooke says no.
Sorry. But truly, and this is the first year we've had it where the case was decided before the tournament, which makes it really hard. Mm-hmm. In the past, it's been, June, so we don't have to worry about it. And so you have to put this like veil of ignorance on your face where you just, or maybe Makaylia has the mask of, where you just, the case is decided, but we pretend it hasn't decided. So this was truly special. And partially mine is because the ends justify the means, because the court has abdicated any kind of fidelity to its own Roshan shocked the conscience jurisprudence. It allows atrocious police behavior in the Miranda situation just because of the magic of Miranda. So nothing shocks the conscience anymore. And I think nothing's even excessive under the Fourth Amendment. So I have little faith in the Supreme Court to begin with. But I do think following the Hadari line of cases, the show of authority versus physical force coupled with petitioner's argument about common law definitions of physical force, what that meant, that when police grab you, right? If my Jeep should have as much protection, I should have as much protection from arbitrary government intrusion as my Jeep does, right? And if touching my Jeep with intent to find information is a search and therefore under the Fourth Amendment protections against unreasonableness, touching me with intent to stop me, even if it doesn't stop me, should be also follow on the Fourth Amendment.
Just recognize, I just want you to remember two things. Number one, when you're in college, don't let any misguided professor try and talk you out of going to law school.
And once you're in college and you want to live in LA and go to law school and come to the most diverse law school in California.
You're not allowed to recruit yet. So that's the first, and you will encounter them. Second, I want you to notice that all of the Supreme Court decisions that create problems for us seem to come from California. California v. Hodari, Rochin v. California. What's going on there?
Because we have a lot of people here, Jeff.
But I mean this sincerely. Jeff and I teach the same law school in Houston. If you guys ever visit Houston next year when you're in person, you come to our class. We'll give you a tour. Yeah. We'll show you around. We'll
come to LA and I'll bring you to the beach and give you a tour.
Okay, well we have Galveston. It's not really a beach. But we'll seriously. You sit in Jeff's Crim Pro class. You come to my common law class. That's an open invitation. You're ever in Houston, come on by or in Zoom.
And unlike Rachel, you can park for less than $45 a day.
Oh my God!
I'll waive it for you.
These two are adorable. I'm so happy they volunteered. Now
I wanted to let you guys know how much the students appreciate a hot bench. These guys, all of these guys, I know both of these programs exceptionally well. I used to teach in one and I'm teaching now in the other. And they are taught the value of a hot bench. So thank you for testing them. That's what they want you to do. Avery is headed off to Emory next year. Not sure where Makaylia is going to go. That was me asking.
I'm going to University of Tulsa.
Which one? Where?
University of Tulsa.
Oh, Tulsa. No problem.
Congratulations.
Super. Brooke and Elizabeth are a little bit away from that. Thank you guys for spending your Sunday morning. Awesome. Hope they made it worthwhile.
Oh, that was, you guys blew me away.
Well, I know people at Tulsa Law School, I know people at Emory Law School. Just keep in touch. We can put you in touch with law professors there. Just you have law schools right on campus. You can go sit in on classes. It's fun. Do you have questions for us for our super duper hot bench from any of the students? Give a chance to ask questions at the case or anything else you want to ask about.
Okay. First thing is a comment, Makaylia, that's awesome. My dad went to Tulsa and all of my family's from Tulsa. So you're in great company out there. Second, okay, let's see. Well, I guess I could direct it to anyone, but when you all have your classes, are you all doing something similar to this? I understand there's moot court competitions in addition, like
not as aggressively. Avery. Generally, not as aggressively. No. you, and we'll, you know, that like, like Rachel was asking you, what is the underlying value protected by the Fourth Amendment? Those are the type of discussions we'll have. But candidly, you're not coming into the law school classroom having studied the case as extensively as you've studied your problem for a moot court competition. And it's challenging to keep up with the volume of work you're getting. But professors also learn, Avery, who their aces are. They learn very quickly in the classroom who the go-to people are. And, you know, you all of you, based on your performance here, if you end up in law school, you ought to expect that you're going to be, you know, one of the people that professors are going to be very happy to see sitting in the first row of the classroom, and going to be using you quite frequently to help them help other students discover the depth of the materials they're covering.
I agree with Jeff. I mean, I do ask questions and some, you know, probing questions, but I make my classes very conducive to, it's a discussion among folks that I expect to have read the material, and I allow them to take passes ahead of time. I don't ask why. Life happens. If you don't want me to call on you, just let me know ahead of time and I won't call on you. But if you haven't let me know, I expect that you're going to be prepared for class. But I smile. I'm like, you can get this. Let's work through this. It's very encouraging because it's a learning environment. Today wasn't per se a learning environment. I'm grilling you because I want to know what you know. And that's a very different persona. But in class, you know, I'm helping you get to where we need to go. I am just a facilitator on that path. You're doing a lot of work, and I'm helping you drive that car to get to the destination. So it's a much more discussive, collegial, in my class, warm environment. It's uncomfortable when a student hasn't prepared. That's the only time I ever get my professor face on. But otherwise it's not the paper chase grilling the one out to make them feel uncomfortable. No, I want them to feel uncomfortable because they're wrestling with what these issues mean, but not uncomfortable because they're afraid of me or afraid of anyone in the class.
Yeah, Rachel,
you'll get different styles, Avery. I mean, every professor has a little bit different take on how to pull the best out of you. And all you have to do when you're a law student is just remember, every single morning when you get up, you're not going there for you. You're going there for somebody else who's waiting for you at the other end of the pipeline. So whatever doesn't kill you makes you stronger, and just go for it.
Thank you very much. Thank you.
Any other questions from the students for me or Chris, for Rachel or Jeff?
I hope Elizabeth, who are the students that are able to do this again next year?
Elizabeth and Brooke.
Yes, I hope you do it again next year.
You're gonna need a new partner, guys. It's hard to get a partner like the ones you have.
Yeah, that's my issue at the moment. I don't really want to find another partner.
Makaylia was in this tournament. Was it 3 years ago? I can't remember.
Yes, it was my freshman year.
She did this as a freshman.
Wow.
And was that the year that Kavanaugh judged?
Yes, it was.
We actually had Judge Kavanaugh judge her freshman year, so she's seen a hot bench before. I think actually Jeff and Rachel are hotter than Brett Kavanaugh was. But is that fair, Makaylia? Anyway, so she was in our final round a couple years ago, and then Brooke and Avery were semifinals last year. So they've done this before. But anyway, this is my honor. I love this so much. It's something I'm very passionate about. We have another round. We have 4 students just waiting in the waiting room, just shivering right now because I know it's going to hit them. So I'm going to call this one to a close. If the students can just leave the room, and I'll just talk to the judges for a few minutes, and then we can start our next round. So thank you very much. You should have my email address. If you don't, I'm going to put it in the chat right now. It's just joshblackman@gmail.com.
While you're doing that, Josh, I think there's just no end to the thanks that we should be giving you as well.
Oh, it's my pleasure.
You spend just untold hours on this every year, and it's clearly a labor of love. I know how much you enjoy it, but thank you for doing that for us.
I hope hopefully. Thank you.
Well, just to send what Dr. Steele said, I want to say thank you to all of our judges in this round. I haven't really, spoken much outside of the argument, but I just want to say before we left and you guys get into the next round, thank you for, spending your time, especially those in California. And of course, thank you to the opposing counsel and even Dr. Steele for sitting in on this round and giving us valuable advice afterwards.
Thank you so much. All right,
I've been texting Ray the whole time, telling him everything that's going on. He's fully informed.
Awesome. All right. Wonderful day, everybody. Take care. Bye in the background. All right. If the students can please leave, if Greg can leave, and then we'll just talk to the judges for a few moments and we'll get ready.
I'm trying to. Where the heck is that button? There it
Big,
is.
big red button.